Good afternoon, everyone. Welcome to this month's MaRS Best Practices session. We have two patent agents from Gowlings with us today that will be talking about patents, sorting through the nitty-gritty. Before I introduce them, I just wanted to say we expect that today's session will be about 45 minutes. Their presentation will be about 45 minutes long. We encourage you to ask questions throughout if you need be. There's mics in the ceilings for the video, so just from your seat's okay. And at the end of 45 minutes, we'll also be taking some Q&A. And with that, I would like to announce our two presenters today. We would like to welcome Shahrzad Esmaili, hope I got your name right, and Grant Tisdall. Shahrzad is a registered Canadian and U.S. patent agent in the Intellectual Property Group of Gowlings Toronto office, and she specializes in the area of patent protection. She's drafted and prosecuted patent applications relating to electrical and computer inventions in a variety of fields, including computer hardware and software, electronics, communication systems, and biomedical devices. She specializes in telecommunications systems, handheld computing devices, visualizations platforms, database management systems, and network architectures. So highly technical stuff, so you probably know how to draft a patent application. And Grant Tisdall is also a patent agent with Gowlings, and he's a registered patent agent with both the Canadian Intellectual Property Office and the United States Patent and Trademark Office. He works with business owners to provide strategic advice and opinions on patentability aspects of their technology, freedom to operate considerations for their technology, and litigation support concerning patent infringement and validity issues. I cannot talk today, I apologize. Grant advises his clients on the strategic global aspects of intellectual property and assists in the coordination of their R&D activities through building and managing intellectual property portfolios for their first/next generation technologies. He guides technology companies in developing customized innovation programs that best formalize their intellectual assets in alignment with their business direction. So very much a strategic framework coming from Grant and Shahrzad. So I welcome you to MaRS and thank you very much for your presentation.
Thank you.
Thank you. Thank you for the introduction and thank you for joining us today. It looks like we have a good turnout. Our discussion today will be quite informal, and if you have questions throughout, you can ask, or at the end, as she mentioned. We'll be discussing patents and their strategic IP use and filing strategies. So, as an overview, we'll be discussing an understanding of IP, patent filing strategies and procedures. What is patentable subject matter, which is an issue that comes up quite often. You may have heard of some recent cases that talk about business methods and software patents and what's patentable and not. What are the risks with early disclosure and non-disclosure agreements, which comes up a lot for startup companies especially. And then Grant will be discussing IP strategies and taking value from your patent filings and how to have an efficient patent portfolio and maintain it. So what are the four pillars of intellectual property? Patents, copyrights, trade secrets, and trademarks. I've mentioned that patents include industrial designs. The patents protect essentially the functional and the structural aspects of an invention. It can be for a process, a method, an article, a composition, whereas industrial designs protect the appearance of an object and the different aspects of that object. Copyrights are right through ownership and are for protecting individual and original expressions of an idea or a written material, and copyright is protected through authorship. Trade secrets, as you may already have heard about trade secrets, they're essentially information that a company may choose to keep hidden or secret, and one of the most famous trade secrets is the Coke formula, where companies decide to hide that information rather than patent because they feel that gives them a better advantage. And trademarks are for protecting essentially words or symbols or logos, marks that are used in trade and in business. And you can register those with the patent offices. What's interesting about trademarks is that they can be renewed while they're being used in business. And for example, patents have a life term in Canada of 20 years from the filing date. So why is it important to protect your IP and to understand what IP is about? IP is an important business asset. It's used in mergers, acquisitions. It helps to define what your product is and what you've already invested in. And it's important also to understand what are the various types of IP, what matches your needs and what your business goals might be, and how to match those. As you can see at the slides, it says the rights, it provides you with a limited monopoly over creations of the mind. It's an intangible property. It's not like owning real estate or a dog or a car, and it's territorial. So you register your rights, and your rights are only for the jurisdiction which you've applied for patent protection. So if you've applied for patent protection in Canada, your rights are limited to Canada only, and if you've the same with the states. And the other misconception is about PCT applications, where people think that PCT application allows you to have worldwide protection, and we can discuss that if that's necessary, but PCT application is a holder and allows you to file in different countries. It gives you additional time to file in other countries if that's what you're interested in doing. What is the requirements of obtaining a patent? And this is pretty much the same across different jurisdictions. There's a requirement of novelty, and that your invention would be new in view of what's been filed at the patent office or what's been published. And sometimes, as we'll discuss, your own publications can be held against you as well in terms of what's your prior art. As well, your invention should be not obvious. So if you have just done a simple minor tweak over something that's existing, an examiner may say, well, it would have been obvious to go from A to B and get to your scope. And so you have to think about those aspects before, it would be useful to think about those aspects before you file a patent application. Sometimes people choose to do a search, or they have an understanding of what their competitors' patent portfolios look like, and so they understand that it's different enough, and that's what they choose to pursue. And so the third is utility, that the invention does what it's described to do, and last is the subject matter. It satisfies the requirement of what the patent offices require. We'll get into the subject matter discussion a bit later. What is patentable? So a product, a composition, an apparatus, a machine, or a process, and improvements to those inventions are also patentable. So there's two snapshots shown of a simple toothbrush and then a vibrating toothbrush, where two different patents were obtained. And we'll talk about also the fact that the patent gives you the right to prevent others from making, using, and selling the invention. It doesn't necessarily give you the right to practice the invention. So in the case of the vibrating toothbrush, for example, you may, in order to use or sell that, you may need to obtain licensing rights from the the original patent of how the toothbrush operated, if that's applicable. And so it's important to note that even though patents can be obtained for improvements, that doesn't necessarily, it may not necessarily give you the right to use it in that way. So the question of what is patentable, and there's a lot of talk recently about business methods and software methods, and I'm not sure if any of you have read or heard about the Amazon decision and the Amazon.com decision about patentable subject matter related to business methods. And recently, in view of that decision, what the court said is that by simply categorizing an invention as a business method doesn't make it, doesn't exclude it from patentability, but that you have to be aware of the fact that your invention can't be an abstract idea or a theorem. So by involving a computer as something that simply implements that abstract idea or theorem, you're not meeting the requirements of patentable subject matter. The Amazon.com, what it was related to, I'm sure you guys have all visited the Amazon website, and where you go to the end and it says for purchasing an item, you can, it specifically says one click. So the patent was related to this one click, and the way it worked was that it would store your user information on your client's machine. So if you'd already, let's say you'd visited a website to make an order, so it would store your profile information, and when you came back on another visit to make that order, when you would simply press the one click, it would retrieve that information from your local client machine, and then fill that information so that you didn't need to do that at every time you wanted to make a purchase. And originally what happened is the patent was rejected because the Commissioner of Patents had said that it wasn't patentable subject matter. It didn't fall under the definition of an art or a process. And the courts came back and said, well, it went to the Federal Court of Appeal, and the court said that Amazon did, in fact, that it did solve a technical problem, that it did provide a solution to a technical problem, and that by simply stating that it was a business method didn't make it excluded from patentability. So it was an important decision. What the court did, it didn't necessarily state that it was patentable, but it sent it back to the Commissioner of Patents and said that it should be reevaluated. And so once it was, in last year, December, the Commissioner of Patents then decided to miraculously allow the patent without any further objections. So there's been a lot of case law similarly in the US about this, and the scope is very similar for business methods and software, in that what is clear is that where you fall is if your invention is categorized as being abstract theorem or mental steps, and where you're just using a computer to automate those steps. You haven't added anything. So that was a brief synopsis, but I think it's important to understand where we stand right now. And then, so again, it just says excluded from patentability are abstract theorems or formulas, and software can be patented as a method or system. Yeah, sorry.
Where does didn't Apple try to patent like basically this shape with like rounded corners? Where does that fall into?
So those were actually, a colleague of mine is giving a webinar on that this tomorrow, but those were related to the design patents, right? So again, it goes back to the appearance, protecting the appearance. Yeah.
So I just want to get clear on, you said that using a computer to automate mental steps is not patentable.
Yes.
What about the steps themselves? Having a process that involves, say, an interview with somebody, leading them in a certain way to produce a result, those mental steps in them. Is that patentable?
Well, so what it goes down to is whether what the court said is that when you analyze what the invention is, and if the novel aspects of the invention are abstract. For example, there was a decision in the States, it was Bilski, where it was related to just hedging energy as to how you for energy trading, and what the court said is that if the steps are simply, if you've just included a computer to just automate those steps, then it's not patentable. But so the underlying process itself has to be, there has to be some so the computer has to be integral to the process. It has to cause a change that wasn't, that you weren't able to do in the human mind, for example, right? Does that?
It also needs it also needs to reach out and touch its environment. So it can't just be something that spits out some result page on your computer. So it's all internal to the computer. There has to be some interaction with some downstream process or communication of the result to another computer that then gets processed in some way. But if it's just a matter of crunching through an algorithm through a set of steps to come out with an answer, it really, that answer has to be used for something, and that something has to reach outside of the computer that's doing that crunching, so to speak. Okay.
So, going on. Oh, sorry.
Steps, sorry, for the medical treatment.
Right. So it just talks about methods of medical treatment in higher life forms are not patentable in Canada.
So how,
go ahead.
what would be higher life forms?
So it relates to
A mouse?
A mouse. There was a,
For instance?
there was a patent related to a mouse that contained a certain genome, and so and I think it was for Harvard, and so you couldn't patent the mouse, for example. Okay.
I had a question.
Yeah.
So,
That's in Canada, though.
Okay.
The Canadian courts, for some reason, took a left turn on that one. So that is okay in the States, and it's okay in Europe. But for some reason, here in Canada, we can't do it. So that went to the Supreme Court. So we're done with that one. But yeah.
Yeah.
so the first, if I understand this, does that mean that if there's a compound that you can't get composition of matter on, you can't protect it if you find there's a disease that it can treat? Like, is there another way to protect it?
Oh yeah, you can protect the composition.
No, if you can't protect composition is in the public domain.
Okay.
So then, basically, does that mean you can't protect developing something?
No, it would be the use of the. So, for instance, if the compound was used as a topical treatment for some disease, then you would patent it. It's not my area, but I mean, mine's more like Shahrzad's. But my general understanding of this is it's in the actual. You patent the carrier with the compound for treating a certain disease, but methods of medical treatment refer to the actual methodology that's implemented by the surgeon or by the doctor. I mean, medical treatment is one. Professional skill is probably one more general way to say that. So you can't. The Canadian Patent Office says you can't patent someone's livelihood out from underneath them. So you can't stop a doctor from treating a patient a certain way.
Okay, so if this is, let me see if I understand. So you cannot patent, say, giving something daily versus twice a day. You can't blocks people from doing.
Well, it would be the steps of, opening up the pill bottle, taking out the pills, administering that at certain dosage on day 1 or at hour 1 and then coming back in hour 2, that type of thing. But in terms of the actual medication itself, the compound within the medication that's known, but not the application of the compound to that disease, that you could patent.
So the use in the indication.
Right.
Yeah,
The
just
use of that
use in
composition.
terms of the compound or composition, not the
Yeah.
not the doctor actually doing the administration of the compound.
Right.
Okay.
And if you're using the composition in a different way or achieving a different purpose, then you could protect it in that type.
And that's all in terms of AZT for AIDS. So you can patent AZT for AIDS because AZT was known but not for AIDS. So that's how they did that. Okay, for instance.
Yeah. So the deal of the patent, how does it work? So the owner provides a full disclosure of the invention, and in return the government provides a grant of exclusive rights to the owner for a set period of time. As I mentioned, in Canada you get a monopoly for 20 years from the date of filing. And it's important to note that it's a right to stop others from making, using, or selling the patented invention. And it's not a right to necessarily practice the invention. It is also a country-specific right, so if you filed a patent in Canada, that's where you're protected. Yes?
Yeah, so I'm interested in that country-specific right. So the US, Amazon has a right to one click in the US.
Right.
If I have a website in Canada, can I have a one-click solution? If they hadn't patented
Right, so it's
or India.
I think software is a funny field, and there was a decision about RIM. It also depends on where how the claims are defined. For example, in Amazon, if there was servers that were operating, did you say you have a patent? Let's say you have a patent in the U.S. but not in Canada.
Exactly.
So how you could capture it, for example, is if some of the servers, for example, operated out of the U.S. And that's it goes back to how the claims have been drafted, and maybe you can capture them based on some of your claims on them being operated out of those other jurisdictions. Yeah.
If I patent something in Canada and the US and somebody sets up a server in Timbuktu doing my thing, I can't touch
I
them.
think so the servers, I think that's a dangerous field that you're talking about, because there could be communication going over that could involve other jurisdictions as well. But let's say you invented a device, a mousetrap, and we were discussing it before the session, in Canada, and you only had patent protection in Canada, then you can't sue someone in the States for using it there. So you have to be aware of that.
Yeah, but in terms of the software, it's all in terms of how you characterize it. You can claim it from the client side, from the server side, between the two, and every case is based on its merits. But the guiding principle on that one is you try to draft the claims for some net benefit in the country that you're dealing with.
Right.
So you don't want to draft everything from the server side. If you want to protect what's happening in Canada, you want to draft, if you can, from the standpoint of someone in Canada via their browser connecting with your server, and then having certain things happen from their side rather than the other.
So then somebody offering that service in Timbuktu would be violating, the user in Canada would be.
That's right, because they'd be violating what you drafted for here in Canada, right?
Yeah.
Can you elaborate on the full public disclosure? To what extent you have to, or you advise to disclose?
Okay, so we'll go into that because it'll come up on another slide, okay? Because I'll be talking about the American Invents Act as well, so I'll get to that. But that's a good question. So practical tips, it talks about keeping your invention confidential prior to filing a patent application. It may be in your best interest because publication may bar filing in other jurisdictions or restrict filing options. And publication includes any disclosure that's available to the public. In Canada and the US, you do have a 1-year time period after your public disclosure to file. And it goes on to the American Vents Act. So the American Vents Act is an act that will go into place on March 16, 2013, next year. And it's an attempt for the US patent system to go from a first to invent to a first to file. So here are some of the captions that you should know. It offers absolute novelty with a grace period. What does that mean? So if you have any type of public use or sale prior to filing a patent application in the US, that's a bar to patentability in the US. And that's different than how the rules stand now. So if you've already had a use or sale, the suggestion is to file prior to March 16, so those rules don't apply to you. And what the American Vents Act does is it gives you a 1-year grace period for disclosures that have been made directly or indirectly by the inventor. And the other point, okay, so I don't have it on the slide, but you asked about the disclosure requirements. So in the US, it's in their rules that the best mode of the invention should be disclosed. Prior to this American Vents Act going into place, if you didn't disclose your best mode, it could be a grounds for invalidating your patent. But one of the rules that will go into place is that it's not a grounds for invalidity, but there is still a requirement that you should at least disclose your best mode. And in Canada as well, although there's not a requirement for disclosing your best mode, you should teach the invention in a way that a person can basically pick it up and be able to practice the invention, will be able to make it and use it, to do it, yeah.
Like a cookbook, almost. You should be able to follow it.
So, say if we're talking about electronics, do you have to submit the circuits or circuit design, or you can just do it at the functional block diagram level?
More at the functional, but you should also, I mean, it depends on how. You don't need to put in every resistor, for example, and it's the same. And it goes back to also what you're claiming, what your claim focus is. And if your claim focus is a certain element that performs a certain function, then you should elaborate on what the circuit looks like for that.
Mm-hmm. Especially if you know which configurations of a circuit will work, and more importantly, which will not. And so if in your functional description you could read that both ways in terms of circuits that could work and circuits that may not work, then you may have to go down to the circuit level.
Okay.
Question about you, because you come from the electronics and telecom, I think you have that
Yes.
background. Could this be a combination of, for example, a software, hardware, and a process? The whole, it could be different combination of different things
Yes.
that reveal a certain result that nobody else can do it. Is that patentable?
So it becomes the question of whether it sounds like it becomes the question of whether it's obvious or not, whether it would have been obvious to combine those different elements and reach that, and if you can argue that it's not. So you could in method claims say that, for example, these are the steps and they're operated by these physical elements, right? And so if you're able to, it goes back to whether you're able to show that there's novelty and that you haven't just combined a bunch of physical and process steps together to reach your conclusion.
It would help if you had a few extra steps in there that kind of adapt it to the particular application at hand. The patentability typically lies where you tweak things that are currently known to kind of apply it to solve your problem to give the end result that's tailor-made to your application.
So for instance, let's say if somebody is doing the same process with a combination of software, hardware, processes, whatever, and then they're doing it at a certain cost, and you're able to do it at another cost. Is
Right.
that patentable?
No.
if it's just substituting out higher price components for lower price components and keeping the same architecture with all the same steps, that's a very tough sell.
Yeah.
But if there's a consequence of putting in a lower priced part, doesn't have all the functionality of the higher priced part, and therefore you have to tweak the set of steps in terms of the order or adding a few extra or taking a few out, then that's when you start to become a little bit more.
Yeah, I mean, it's not necessarily the part that you're replacing with the higher to lower, but let's say it's a combination of, for example, a software tweaking and nobody, or a methodology, nobody could do it. You have the same grade of components, for example, on these circuit boards, but you have some software.
Then the patent is in the steps. Okay, yeah, that's fine, that's valid, because the patent is through the process, through the steps, so it's the actual path you take. So if you take a different path to get from point A to point B, then that's your patent. That particular path, or what we do is we broaden out that path to to contain a certain subset or general set of paths that all fall within the same framework.
Yeah.
It seems that the more detail you put in, you say make it almost like a cookbook, and someone else would read that and without much trouble would find another way to do it. Unless you put all possible recipes in, the patent would be hundreds of pages in some circumstance. I've seen patents with tremendous detail, and I've read them and I said, well, there's other ways to do the same thing.
Right. Patents have two parts, though. A lot of people read patents by looking at the title, looking at the pictures, looking at the description, looking at the claims. And so it depends what you pick. Some people, I've had people say they've got a patent on one click. I say no, they don't have a patent on one click. I know the title says one click, but there's more detail in the patent in terms of what that truly is. And then they read the description and they go, well, I don't have to do this, and then it doesn't matter. Well, not really, because it's in the claims now. If you get to the claim section paraphrases that detail to specifically what you think are the steps or components of steps that are where the invention truly lies, and then kind of strip out all of the other extra bits.
So it's the claims, we're going to rely on the claims for the generality of the claims, and we're going to rely on the description to say that you actually have something useful.
That's right.
Right.
So when you say doing X, then in your claim, then the description should have some discussion on what doing X really means, rather than just the 3 words that are in the claim.
Come along later and have another way to do X, it's too late because they've already claimed doing X.
Exactly.
Okay.
There are some companies that are working very strategically, like big technology companies that patent around a core idea. So they keep the core idea secret and they patent things around that core idea. So then it creates a sort of level of secrecy there that they don't disclose.
Yep, you can do that.
I think what you have to be aware of, and it goes back to your question about disclosure, is also part of it is related to during prosecution, because if the examiner comes back and shows you that, okay, your invention is obvious, you want to have different, as you said, different ways of doing it that you can fall back on if you need to narrow the claims and to convince the examiner that your invention's different. Okay? So I think we've discussed the disclosures and the risks of disclosure, and then if needed, you should obtain a non-disclosure agreement. And some of the issues with non-disclosure agreements are listed. Essentially, non-disclosure agreements, an agreement with the person receiving the info to keep the information discussed as confidential, and also it serves that the information you disclose according to an NDA, doesn't count as a public disclosure. So it's not counted against you for patentability purposes. But there are other risks in that there could be a breach of the non-disclosure agreement, and disputes may arise as to ownership. And as you mentioned, if you disclose too much, the person could, for example, think of different ways of implementing it, file their patent application. There's a lot of potential for dispute. So it goes back to the safest bet, if possible, is to file a patent application. And the other point to note is sometimes the NDA may be drafted may be biased according to the party signing it. So you have to be aware and make sure that you do have someone look over the NDA. And with that, I bring the topic to Grant and on strategic IP filing and some of the decisions that you make throughout the patent process.
Great. Thanks, Shahrzad.
Thank you.
I'll have to excuse me. The last time that I've been under this much of a bright light situation was when I was in grade 11 band. So I find it a bit daunting trying to see people. So if I don't catch you, then you're going to have to wave a bit more because the people in the back row are a bit dim. I was talking about, so my background as well is in software patenting, high-tech companies. I also do patenting for some automotive clients and a few other more mechanical-based process type products. That, but mainly my practice was 70% is high-tech software and business methods, user interfaces and such, and then the other part is the mechanical aspects. Although these days, even the automotive clients, they're becoming more of a high-tech product than in years old. So I want to follow up a little bit in terms of what Shahrzad said, is that what you're trying to do here with this animal, with this patent animal, is to protect an intangible asset. And when you start thinking about an asset that's intangible, which is different from a car, real estate, or a dog, there is some similarity with that in that, because I remember the last time that I had a dog, the dog owned me, I didn't own the dog. So you don't want your IP to own you. You want to kind of own it. So, and you can get in pretty deep pretty quickly in terms of costs and other resources such as a lot of time and effort in maybe patenting something that you might necessarily have not done if you had a thought about it a bit more at the beginning, as well as you may you may have not patented some things that you would rather have done, given the ability to go back in time. So the patenting process is not something to go into lightly, and you need to take a look at a lot of different factors, such as what's listed there: customer, market size, competitors, whether patenting in your space is something that's looked favorably upon or not, due to the market and/or due to potential investment or other partners. You need to take a look at your product and process development, how long of a time span that's going to be, what you're going to know and when throughout that process, and then have some understanding of when to contact a patent agent and start asking questions about what should I do. Should I patent this or not? And as per what Shahrzad was talking about, you don't want to start asking those questions after any potential grace periods, after you've done a public disclosure, after you've talked to a prospective client not under an NDA, handed over confidential information as a way to catch their attention. There are a lot of things you can do to mess up your strategy from the beginning, so it's kind of nice to know what those potential deal breakers are going in with your eyes wide open. So in terms of cultivating value from IP, it really is taking a look at what you have and what you want to do with it. And what I mean by what you have, it really is what value add are you bringing to the marketplace through your technology, and concentrate on what that value add is, and then with that filter, take a look at, is there anything in there that I can protect, something that you can do at the beginning, and also ongoing as your technology or as your product develops through the lumps and bumps and dips in the road as you're dealing with partners and the marketplace and such. Okay, so having somewhat of a regular review as well as an idea how to conduct that view properly from the get-go makes a lot of sense. Internal versus external for IP audits. This really is a matter of getting all your ducks in a row. You don't really want to start down this process of deciding what is my IP strategy, what is IP, what is a patent, should I trademark something, how does copyright compare to patent protection, shouldn't I just get an industrial design because it's cheaper, should I just file a provisional patent, can I file an international patent? Can I get international patent rights? All these types of questions are questions you don't want to be asking yourself when you have investors knocking at your door and or a patent holder knocking at your door saying you're doing the wrong thing. It's kind of the wrong time to ramp up in terms of your knowledge base on what IP is in theory as well as practically how it maps onto what you're doing. So the first step is to develop an IP strategy or to at least get an understanding of how IP does or does not impact your company, as well as in going through some of those internal processes. When you get to the external process, you're not looking like someone who has all of their receipts stuffed into a big duffel bag and you hand it over to the tax man and go, here you go, here's my IP. And they kind of want to see a little bit of organization, methodology, and again, that's not something that you can do in a few weeks or a few days or even a few months. It takes a bit longer than that to have that done properly.
Question, so
Yes.
how much do you have to demonstrate that you can actually practice when you're trying to protect yourself? Like what sort of data do you have to support that you can actually make the invention work?
Give me an example.
So, okay, going back to drug development.
Without disclosing anything. We're not under NDA today, but okay.
So going back to drug development, so using a compound that has no protection for composition, but you see a novel use for it.
Right.
And so you're going to do some data, say in an animal model, to develop it. So at what point do you file? So do you file early before you have the data and then backfill it once you have the data and it looks good? Or
that's a fact dependent. Drug companies typically file multiple applications up until their convention period, so year. So they'll file they'll start the process rolling with a provisional application, for instance, for enough that they think merits some general direction of where they're going. Then they'll backfill that up to the year, and then they'll collect all that after a year, and then file it as a full-blown application. There's some stuff you can do post that at the time of publication of the application, but all of that in mind. The recent case that came up was the Teva case for Viagra, and so Pfizer lost that patent here in Canada because they didn't give enough disclosure in their application. They did give disclosure in terms of the compound that worked, but they also gave other compounds in there and didn't. And they suspect at the time that they knew that those compounds didn't work, but they were also in the claims. So in terms of the public notice, the public wasn't really sure which compound worked and which compound didn't, which ones to stay away from if you don't want to infringe the patent, and then which ones you can practice. So I mean, that's a loaded question and kind of a loaded answer, but the more detail that you put in, the better. The more detail you put into your disclosure, the better, because you don't have to claim it all, but you do have to give someone kind of the keys to the invention. And the problem with the theory is that you don't really know what the invention is until your back's put up against the wall with the examiner saying what's novel and inventive and what's not. So what you started off with the invention over here, suddenly it shifts over here or over there, and then you're very happy with getting that those claims, but you kind of have to make sure that your description fills in all those missing pieces in case your claims have to shift. So it's a little bit of strategizing in terms of the content that you think you're going to need, kind of like plan A, B, and C as you go through the patent office. Does that answer? Yeah. Yeah. Okay. Great. So the anatomy of an IP audit. There's a lot of things on there. There's a lot of ways that you need to go through it. You need to, inventory all your IP assets, confirm ownership of all your IP assets, access or assess whether the assets are relevant for the commercial goals. I mean, those are all great points. And they're all things that you do have to go through. But as a general gist of what that is, you really have to start with, because patents are written on a problem solution approach, so you have to know what problem you're trying to solve. Where's the impasse in the marketplace? Where's my value add going to be? Why am I or how am I giving it this value add? And then once you've got that focus with where you're coming from or where you're going to, then you start to talk about how you're going to do that, and that's your solution. And then with that filter on, then you start determining more so in terms of what are the details of my solution, what's different from my solution from what's out there, what differences are critical to make that value add happen or not so critical to make that value add happen. People could substitute something else there and still get that same effect. And so that's your basic starting point in terms of an IP audit, typically through a brainstorming session or preferably something that happens earlier on with your own people, and also get a patent agent involved to bounce ideas off in terms of this is what we like to do, what do you think based on what we have. Once you get that under your belt, then you can start asking yourself the questions of, do I have to worry about copyright? Do I have to worry about functional protection that would be provided by the patent versus the code lines that are protected by copyright for the software, selling copies of the software? Are there branding issues I should be looking at in terms of first to market or maintaining a foothold in the market based on the name, which is not a patent, that's a trademark? Is there some of the internal know-how? It was mentioned earlier is you could offense patent around an idea or a methodology that you actually don't patent or don't disclose. But the interactions with that, as long as no one can figure out what's inside your black box through those interactions, then you patent those. Or do you patent what's inside the black box because realistically once you start to interact with it, you kind of know what's in there or enough of it to be able to figure it out. So you can see that when you start with the patent, get a sense of what your value add is and what your marketplace is and what your problem is, what your solution is. Then what falls out of that is really what should I patent or not, and kind of what are the implications. And that's really how to do an IP audit. So we talked about business goals. There's an order in which you can do things because all this realistically costs money and time. And so, do we worry about freedom to operate? Do we try to block other people's technology? Do we try to invalidate our other competitors' patents? Do we patent our own technology? That's a lot to bite off. So one thing to start with is really focus on what you've got and how to protect it. At the end of the day, that's where your value add is going to be, and your value add hopefully will be valuable to someone other than yourself. And if that's the case, then you're going to make money on it. Spending all your time and effort to stay away from someone else's intellectual property is not necessarily giving a value add that's tangible of that intangible, and so it may not be as attractive to someone in terms of giving you money for it, that information. But the general progression is to protect your technology first, and then take a look at what other people are doing and how close or not close you are to other people's intellectual property.
Wouldn't that surface on the research before filing?
Yes. Yes and no, because the freedom to operate and patentability are, so in infringing someone else's patent versus getting your own are two sides of a coin. They're not on the same side. So you're really looking for has someone else described what you do. And it's fairly easy to get through that in terms of a search, as long as people are using the same words that you're using, or similar type words. The other side of the coin is and so that's the search that you do to see whether what you have can be patented, because it's different from what other people have done. The other side of the coin is seeing, are you infringing someone's patent claims? The claims may not even be in your area. They, you could be in software, and the claims could be in some medical field about how to process a bunch of data. Trying to find that claim is very difficult, and you may not even find it. And it certainly won't find it when you're trying to search your own application. So they really are two separate searches with two different emphases. Yeah. So I have had one search done though where both which was nice. It was for office furniture. Both the patent that said we could not patent and the patent we would be infringing were one and the same. But I've only seen that happen once personally. But normally they're in two different documents. Okay, IP inventory. So in terms of the IP inventory, all I can say here really is you kind of need to keep on revisiting this. Set it up at the beginning and then revisit periodically as you go. And it really is in talking to a lot of different people in the company, not only your technical people, but also your sales and marketing people, people that you value in terms of being a trusted advisor, both within and outside your own marketplace. You need to have a lot of information on the table, and then look at that and decide, is what we're doing something that can be a value add? And if it is, then go through that process of, is this something we should patent? Is this something we should keep to ourselves as a trade secret? And so on and so forth. And the nice way to do this is, I've been involved with many sessions where you just get a bunch of people in the room and you brainstorm the hell out of it. You just talk about it and put an idea out on the table, and everyone has a healthy debate in terms of why that's valuable or not. That's typically where all these things start to fall out. So I think we talked about this already, just some of the considerations. Shahrzad went through which forms are best for which types of assets. And IP asset is different from an intellectual property. An IP asset is something that's not yet been formalized. So it's an idea, it's something that has not yet found its way into being a trade secret, a patent, a trademark, or copyright. And also, by the way, a trade secret is not a trade secret just because you didn't tell someone. Trade secret is a trade secret because you've put specific structures in place to make sure that secret never gets out. So you have to have limited access. You have to have that idea codified in some documents so that you actually know what the idea is. I once had someone come to me and say, someone stole our technology, and what can we do about it? And the problem was they couldn't, because what they did was their former employee left their company and then started their own company and were competing fairly successfully with their product offering. But the person who came in to talk to me couldn't really tell me what was the deciding factor to make these other companies go with their former employee, nor could they really tell me what was stolen. And if they could tell me it was stolen, then where was that information located? Was it locked down somewhere where only certain people had certain access, password access and such, or was it just in user manuals that were sitting on the shelf in the office? So you do have to be careful with that. Just because you're not doing anything doesn't mean you're doing something with respect to IP, formalizing it. All I'm going to talk about here, because we're running out of time, is confirm ownership of IP assets. All IP comes from a person, not from a company originally. So you do have to be careful with your contractors, subcontractors, employees, developers, engineers, however you want to quantify it. There has to be some, preferably in writing, why what they're doing is yours and not theirs. And that's not something you want to do after the fact. I had a situation where a client of mine had to drop their PCT application because they couldn't satisfy ownership. The reason why they couldn't satisfy ownership is because they had promised compensation to the one of the inventors in exchange for assignment of his rights over to the company. I didn't know that. I was told that he would assign, and so after the fact we filed. Then that's when things became interesting, and there's a lot of interest in the technology. So the former employee thought he could get more money out of it than just what was agreed upon verbally, and so we kind of went nowhere with it, and so ownership tanked very quickly. So you do have to be careful with that. And also, if it ever gets down to what we mentioned earlier in terms of the external diligence with respect to financing or M&A work, they're going to want to see clear title to whatever you have. It's really not something you want to deal with 3 years down the road. You want to have that dealt with up front, quick. I won't really get into this slide other than just to say that there's a lot of options when it comes time to filing an invention in specific countries, within the country, between countries, coordinating what happens in one country versus the other, what your priority application should be, where you should file it, what the content should be, what the content maybe shouldn't be. Everything sets a clock ticking, and there's some times on here, or periods, and those are non-extendable periods. Yes?
Yeah, a question about the right-hand side on the PCT system.
Yeah.
We're going through the process now, and we've passed the first 12 months.
Yeah.
So it's time to decide which countries to go to. And one thing we're faced with is actually two issues. Some countries we want to go to, we think, but we're questioning the enforceability of the patent. China, Brazil, India.
Yeah.
And then there's another group of countries like Japan where we're not sure we go, but it's such a big market, we might go in 10 or 15 years from now. So what would be your advice for those two situations where in one case you think you want to go, but is it even worth anything, so should you spend the money? Or in the other case, you're not sure you want to go, it would be enforced, but it only help you 15 years down the road for a small company like the one I work for.
Given the choice of only one, which would you pick? Okay, so then given the choice of, so if you had the choice, would you pick both options?
I mean, my instinct is to go with the ones where I'm more sure I want to go to, and the enforceability is more of a question mark than the long-term investment where we might not actually need it. Yeah. That would be my instinct.
Yeah. Don't forget that that patents are something that can be used to enforce your rights, certainly, but they can also be used as an investment vehicle. And you're probably going to get to the investment well before you get to the enforcement stage. And so you, like you, everyone else is also not sure in terms of what the enforcement potential may be 10, 15 years down the road in China or in Brazil. So people are buying, what they do there is they buy that option of that possibly happening in 10 years or in 5 years. So that's kind of where the value creeps in. If you think your value is going to be in being able to capture a chunk of the market in Japan where you will be able to enforce, but that may not sort itself out for a certain period of time, then number one, Japan's a very expensive jurisdiction to get patents in. And it's very tricky too, because they're fairly straight and narrow in terms of how they do the patent prosecution. So it would be best to try to pick a bit of both rather than putting all, it's kind of like putting all your money into your house in terms of that's my retirement, right? Versus putting something in RSPs and your house versus all RSPs and then renting. It really is, it's best to kind of spread it out if you can, right? And that's probably the best way to own it rather than it own you type thing, yeah? Okay, so that kind of answer at all? Yeah, okay, so in terms of the time periods on there, they're all non-extendable, so you really do have to, once you start, the big thing is once you start the ball rolling at time zero, you're kind of locked into that timeline. And so you do have to have a sense of where you're going. You shouldn't be figuring out, should I file in more than one country at 11 months and 59 days? Or, which countries do I want to pick? Or what countries would be useful at the 29-month window if you file the PCT? You really should be doing that a bit further up the time scale. I'm just going to take that as being that there are different ways to make the examination of the patent go through the patent office. There are reasons why you may want to get a patent earlier, or you may want to let it float and not let anyone really know what the ultimate claim scope will be until later on down the road, because it's advantageous for you to keep it general. If there's someone who's infringing what you're doing and is taking a piece of your business, then maybe you might want to go faster. If there's no real reason and people seem to have enough interest both from collaboration as well as financial considerations, then let the patent float and not rush the examination. It's all kind of a case-by-case basis anyway. That's just typically what you do. In that you really should be clear from up front in terms of what you're what you want to do with the patent rather than just it's a great thing to do. And as long as your patent agent knows why you're doing it and is in the loop in terms of product development, then that helps have the applications pretty focused, and then that kind of takes care of most of that anyway. So same thing here. Number 3 is probably the biggest one, is draft the proper application. And number 5 is file strategically. Those two are probably your 2 biggest cost options, because what you draft will impact what you examine or prosecute before the patent office. And once you get 3 and 5 done within a certain clear-headed order, then number 8 is something that kind of comes next. Actually, 9 should be at the top, but anyway, maybe I'm just biased. And then lastly, those are all really good points in terms of you really shouldn't be telling people what you're doing before you've made a decision to patent or not, and know what that really means rather than it's just theory. You should know in practice what you would want to patent or not patent, and then based on that decision, what's okay to disclose to people outside of a patent application filing happening prior to that disclosure, or not. You don't, even in a grace period situation, you don't really want to have to rely upon that, because that restricts your opportunities pretty quickly in terms of the number of countries that you can go into. So let's say that you disclose the caramel secret here in Canada, and then someone comes to you 6 months later and says, I'd like to file, I think we'd have a good go at filing that and prosecuting that and capturing a piece of the market in Japan. You come to me and then I go, we're not going to Japan. We're just going to stay here in Canada and probably the US and maybe Australia, which you're not interested in, and potentially Mexico, depending on how you disclosed it. And then after that, we get down to banana republics. So, yes?
Why are patent filings so expensive? I mean, Gowlings, your company is pretty much the most expensive out there to go with in terms of patenting.
Define
I don't
expensive.
know, we agree.
Well, I think that, I've been looking for about a year and working through the patent process for about a year. We have a software application for mobile. And, you get things from like $5,000 for a provisional patent, which is pretty outrageous, to, $40,000, $50,000 that I was told Gowlings is the average or kind of like minimum that you'll get yourself into to file a patent with your company.
40? That's what yours was.
Yeah,
I wish I could do a few for 40, but no, actually, I don't do that. But
like a minimum.
really, I'm not sure who you're talking to, but no, software applications, and this is something in terms of software. Those applications for a proper application, it depends on what you mean by application. Because if you've got 6 inventions and that's not an application, that's actually 6, right?
Right.
But if you have an invention with stuff around it that's fairly closely related, and it's fairly focused, then $10,000 to $15,000 is kind of what you're looking at.
Does it depend on how many jurisdictions you're going to?
Yeah, so it depends. Those
That's
are
the file.
Those are
that's
the
draft
filing
it,
fees,
and,
right?
and then you start paying the filing fees, right? So,
Yeah.
for instance,
So that has nothing to do with.
paying. So sure, 40 to 50, you may get there if it comes down to paying the $10,000 ticket to get into Europe, to pay the $3,000 ticket to get into the U.S., to pay the $4,000 ticket to advance the examination, to pay the $4,000 ticket to pay the associate in Australia to file it for you in their patent office. So you start to add those in, then definitely you'll get to the 40 or 50 grand, certainly. But I mean, that's outside of Gowlings' control. We're not really adding those costs in. And I know for a fact that any of the other firms all charge approximately the same amount, give or take 10-15%, and it's always devil is in the details in terms of how it gets done.
You would say then, is it fair to say that an application, so patenting one element or one item should cost for drafting the patent between $10,000 and $15,000?
That's a good ballpark. Yeah, it's a good ballpark, and then you kind of decide what you want to do with it from there. Yeah. Yes.
Just on the disclosure part, so if you're developing that's public disclosure. Right?
Yes.
So if you're in doing private beta testing and modeling and refining your idea, but as long as it's private, that's excluded from. That's not.
Yes and no. Okay.
I understand the disclosure, the risk of those people running off with your idea.
No, not just that. It's in terms of the U.S. We never covered it, but the U.S. has an additional disclosure requirement which is in use or on sale.
Yeah, we talked about a little bit, right?
So
yes, you did mention that.
So even if it's under an NDA and it's all secret, if you've been capitalizing on the invention in the U.S. for and that's a case by case in terms of what profit means, right? But if you've done that for over a year, then even though it's not been publicly known, you're still barred from filing in the U.S.
So you have a year.
Yeah, that's
And that's particular
No, so
to the US
in-
or anywhere else.
that's particular to the U.S.
To the
So let's say you have an invention and you've been making profit of this in other parts of the world, but not in the US.
Yeah, I wouldn't say profit. I just say capitalizing on it for whatever that means. You could not have been. You may not have been making any money, but you've been getting some advantage from it.
Right.
Yeah.
But if that is advantage is gained somewhere else in the world and not in the US, that's still patentable.
No, so actually, that's a good question. It's I was talking about the new American Invents Act that goes into place. It talks about prior use or sale anywhere. And that could be a bar to patentability. Now you have a question
the
whether,
US.
sorry?
In the U.S. Sale. It's in the U.S., right? If you sell a black box and no one can truly figure it out, for instance, if you sell
No,
a chip
foreign
and it
offers for
melts.
sale count.
Right, but patenting in the U.S.
Right, so this is a bar to patentability in the U.S.
Right,
I thought you meant the
Yeah,
sale
yeah.
is Yeah.
Sale could be anywhere, but patent cannot be done in the US.
In the
Right,
US,
so
yeah.
this is, I'm telling you specifically for
Exactly.
the American Invents Act for filing in the US, according to the new rules, if you have prior use or sale prior to your filing date, it could be a bar to patentability.
But if you've, say, had a process that's been a mechanical or, say, a human process, and then you turn it into a computer process, and that was all in use, and your computer process is new, that's
Okay.
an improvement,
Okay,
and that's patentable, then
but then it goes back to the whole patentable subject matter. I think you're
but
into
it's
different
not
realm.
barred by the, if you're billing it as an improvement, it's not barred by the,
Yeah, it goes to what you're claiming, right? So at the end of the day, what your claim scope is, if what's defined by that, if there's been, and then it goes back to what I mentioned in terms of tips that if you, because according to the current rules, if you've had sale in the U.S., you have a 1-year period. So if you've already had prior use or sale, you may want to file before that March 16 deadline.
So
to
yeah,
avoid.
so that's kind of point number one. And point number two is make sure you own what you want to patent. If you don't own it, I don't think you want to spend $40,000 or $50,000 doing it in multiple jurisdictions. Or number three is patenting the wrong thing or not patenting the right thing. That can become a bit problematic too. And that is the end of our talk. Yes.
Do you have a process, like a software, like he was mentioning on interviewing, but you go through user testing because you need to test this out. Is that disclosure?
Well, I mean, generally, if you want to think of it, again, all these things can be fact dependent in terms of what content and what they would have known or understood or not understood. But generally, in terms of a disclosure, if someone feels okay to go home and talk to their spouse at night or lean over the fence and talk to them about it, or go talk to someone from outside the company during lunch, if they don't feel like they shouldn't do that, then I'd say, yeah, what you gave them in terms of information would have been a disclosure, as compared to, you're not supposed to talk about this with anyone else unless you let me know first. Or if you put it up on a beta test site that's not password protected, well, that's a disclosure because anyone could have keyed in. Not necessarily they had to key in, but the fact that they could have. If there could have been a web crawler that could have caught that content, whether or not it actually did do that, it doesn't matter because it could have happened, right?
So as long as it's in a closed system, like you're mentioning,
Yeah, it has to be locked down.
then that's still not public disclosure.
Yeah, that's locked down. Yes.
So I have a question in terms of process. So I've recently started working with a startup company who started their patent application process back in 2008, so before I was involved. They've used 2 different lawyers. One set did the application, and then they're using another set to do the back and forth with the examiner.
Okay.
The prosecutor, right, okay, sorry.
Yeah, sure, that's fine,
Called
yeah,
the examiner.
yeah.
What's happened recently is it's gone back and forth to the examiner's office twice, and we just recently received a final rejection. As I've gone through the patents, both the patent application, our back and forth with the examiner's office, and all the patents that the examiner has cited, I do see a difference between what we're doing and what's already been cited, but what I notice is our application was weak, and our rebuttals have been incredibly weak. So what I'm wondering is, now that we've got this final rejection, I understand there's still an opportunity to go back, but how far back do we go back? Do we redo our application so it's stronger? Do we just concentrate, where do we focus our efforts?
Well, you can go back to the patent office by filing another fee, and then you can get out from underneath the final action, so you can argue further.
Okay.
So there's that. That's what could be meant by going back.
Right.
Yeah. And if you want to add, if what I'm hearing you saying is that your rebuttals have been weak because the content of the application was weakish.
I think it's a mixture.
Yeah. So I mean, you can only claim what you describe. So we talked about earlier in terms of your description has to be fairly detailed. A cookbook, as much as you want to put in there, because at the end of the day, what you want to claim has to be in that description and drawings. So if you don't put it in there, you can't claim it. So you got to kind
It
of.
has to go
It's in
back
there,
to
but
what's
what they
the
haven't done properly, which you guys were talking about earlier, is they haven't really articulated crisply the problem and what they're solving, and how it's different from prior art. So
Yeah, no,
they've
that's
got
okay.
their stuff, but they
Yeah.
just don't have the description part isn't very solid.
Yeah, no, that's okay. I think that's okay as long as you can rely upon some good content that talks about structural differences between what you have and what the prior art shows or doesn't show. The rationale as to why you include it or not, it's always nice to have in the application those advantages, but at the end of the day, you're still able to argue that outside of the content. But if you need to put a particular claim limitation or set of words in the claim to show, see, the reason why we're different is because we process A times B rather than A plus B, and the prior is A plus B, then you have to have A times B in your description. If you don't, then you're stuck. Even though you know what the difference is, you can't claim it. Yeah.
Yeah.
What's in terms of really getting all the description down, how much of that has to be in a provisional?
Everything. If you want to,
What's the difference between a provisional and the...
There's not a lot. The difference between a provisional and a formal is some of it is the format. You could literally write the provisional on a cocktail napkin and put it in an envelope and send it to the U.S. Patent Office. Yes, you can. But
Not recommended.
But not recommended. Yes. But you or like sketches, or it can be very informal in terms of its presentation. But the content, the actual descriptive content, has to be virtually identical to what you want to protect. Because one of the reasons why you're filing the provisional is because it gives you a sense of security in that I filed something in a patent office. I'm going to rely upon that date for priority, meaning that anything that happens after that date of filing the provisional, I disclose, the competitor comes out with something gets published, then if that's intervening between my priority date, my provisional, and my actual formal application, I go, hey, wait a second, what I'm claiming over here goes back to here. So it will jump back in time, and then it will kind of negate what's in the center.
So you're saying it needs
But it can't be there if the content's not there. You can't claim it later if it's not earlier.
content needs to be complete.
Yes.
And my content is complete, but I don't think it's very well written. It's not written in the way a patent is normally written, and I need to have a
You can modify that, that's okay. I mean, you do run into, if conceptually one skill in the art could rearrange your content to mean what it's, or say what you think it should say, without really changing the conceptual bits of it, that's okay to do in the US and in Canada and some other jurisdictions. Where you run into problems is when you get to Europe, because Europe these days and Japan and some other countries are kind of jumping on the European bandwagon. They want exact literal support. So not only do you have to be talking about what you're doing in the paragraph where your words are, the words you're taking from that paragraph to put into your claim have to be exactly. You're not allowed to change a comma. It's that gets plopped into your claim. So if you want to change the order of the words, or if, for instance, it's making my life more complicated these days, I'll say that I could do any one of a combinations A or B or A and B or A and C or just A or B alone. And then when I come to claim, I go, I actually want to claim B alone. A plus B sitting in the middle of that phrase. EPO will say, no, you got to use the whole phrase. You can't take a piece out of a phrase. You got to either use the whole sentence or after the comma or not at all. So I have to go back and say, okay, it could use A, period. It could use B, period. It could use A or B, period. So it's different in terms of how you draft it. That might not necessarily impact you in the US, but it could in Europe.
So it goes back to understanding, as Grant said, in a provisional you don't have to adhere to a specific format, but often what we'll do is at least put in one claim so that you have an idea of what your claim perspective will be and use that similar language.
So I was told to leave the claims section empty, but to make sure that the claims that I would want to write are
You
all
could
somehow
put in a claim,
the
there's
description, but
nothing
not as literally
preventing,
as-
yeah.
Well, yeah, and it can be difficult because you get clients coming. You say, I only want to file provisional. We'll only file the descriptive content. That's fine, but I don't know what I'm going to claim. So, and when you claim stuff, you kind of are a little bit looser with the language terms. You want something more general. So, for instance, in in the specification, I describe, this is connected to this via bolts, screws, rivets, and string. And then in my claim, I like to say, that's connected to that by a fastener. And so that's what I want to claim, but what's in my description is one of those 5 things. So in the US, you might be able to say fastener. In Europe, they're going to say pick one or all of those 5. So if you can use rubber bands, then the claim is garbage.
What I've done after the advice of don't write claims, I wrote all my claims, and then I went back and made sure that all my claims were covered and described and so on, and still left the claims out of the actual submission.
Yeah, you can. I mean, there's differing views on that.
I changed my description a lot after having
Sure.
said, now that I forced myself
sure.
to name my claims,
Yeah, for sure.
I missed all those things.
Yeah, for sure. Yeah. So that's why it's very hard to draft a patent application properly unless you do both sides.
So
that's the exact.
But I should still not
that's
actually
exactly.
put the claims in the provisional, the actual section called claims, what we claim is. Leave that out, but still make sure it's all in there.
There's different interpretations on that as to whether you should include just a general scope claim or because Europe is problem solution, so they kind of want to know what you're claiming, and if you don't. It can cause problems later on in a prosecution if it's not clear what your invention was from the start. And so what's changing tracks or not changing tracks, and sometimes you can't change tracks later on down the road if
No,
you're
you
not.
can't change tracks like that. I understand that.
Mm-hmm.
Yes.
If I have a product use a chemical to make this product,
Yes.
and one day people see these 10 chemicals, they add one extra irrelevant, no functionality change, but they just claim this brand new product. Can they do that?
Well, patents are typically the smaller subset, right? So what you claim, in order to infringe the claim, you got to practice every element that's in the claim, give or take. So if your chemical has just A and B in it, and you claim A and B, a chemical with A and B, right? That's your claim. Someone adds C to it, well, their ABC chemical has A and B in it, so they would infringe your claim. Okay? That's kind of how you interpret claim language on a broad brushstroke. 15-second example. Yes?
So to wrap it up, I think, what's the next step for people here? Like, I'm sitting here still wondering whether what we're doing is patentable.
Yeah.
Right.
So it gets back to going and getting someone in to bounce ideas off of in terms of just basically go up on the whiteboard and explain what you're doing, explain why you're doing it, explain what you think is unique or not unique, why, and then it's up to the patent agent to sit back, come from an outside point of view and go, I think you should do this, I think you should do that. That's going to cost money. I don't know, I think you should do that third, maybe, but you tell me different, and you kind of sort through it.
Where do I find?
You call Gowlings, you call only Gowlings. No, you call. That's what they pay me to say. No, you call a law firm to sort it out.
Thanks so much.
Okay, thank you very much for coming. Thank you. Thank you.